So with that, I'd like to introduce Mike Farris. Mike Farris is the president and CEO of the Alliance Defending Freedom. He was the founding president of both the Homeschool Legal Defense Association, who I work for, and Patrick Henry College, and serves as the chairman of the board of HSLDA and chancellor emeritus of Patrick Henry College. Mike has a Juris Doctorate from Gonzaga School of Law and a LLM in International Law from the University of London. Mike is a constitutional appellate litigator in the US, among other things, an author as well. He's written many books and has argued before the appellate courts of 13 states, 8 federal circuit courts of appeal, and the United States Supreme Court. Mike is a homeschooling parent. His wife, Vicki, and he have 10 children and many grandchildren. And it's been a privilege for me, Mike, to have worked for you these many years, and I consider you a mentor, and I really appreciate you. So Mike, please share with us your decades of experience and insight on these important questions. Mike Farris, thank you.
Thank you, Mike. It is good to be with you. I guess I'm obligated to tell you a lawyer joke, but
no, you don't have to if you don't want to.
Actually, there are only 2 lawyer jokes. All the rest are true stories. So we'll let that suffice. I wanted to share some lessons that I've learned through. It's getting close to almost 40 years that since I started HSLDA. It's 38 years ago. And so some litigation lessons and some organizational lessons, since the question before us is designed to help various countries start nationally based homeschool legal organizations. I want to talk about both litigation and organizational ideas. So the first question I'll begin with is, why did I start Homeschool Legal Defense Association? And this requires a little bit of background. My wife and I began homeschooling our kids when, we made the decision when our oldest child, Christy, was, it was April of her year of first grade. So she was 6 years old, and she had been in kindergarten and in first grade in a Christian school. And we heard about homeschooling, and we decided we were going to do that starting the next year. We go ahead and finish the year of another couple of months in the Christian school, and then we began homeschooling. I was very active in basically precursor kind of organizations to Alliance Defending Freedom in Washington State at the time, and had a statewide recognition, mainly among Christians, but to some degree in the general public. And the word got around that this Christian lawyer who does constitutional litigation was now a homeschool dad. And so I started getting a fair number of requests for legal help in the homeschooling context. And when people would say that, well, they wanted a Christian lawyer to help them, what they really meant is they wanted a free lawyer. And so Christian lawyer was simply a shorthand way of saying, you need to do this for free. And I realized pretty quickly that this was a good way to go broke, and that it wasn't realistic for people to expect, especially with something that appeared to be growing like homeschooling was, for it to work very well if it was all free. On the other hand, very few people could afford to pay for the full freight of legal services it would take to do constitutional litigation. And that was what was needed in the early days of American homeschooling. It still is needed to some considerable degree. And so the only way to get both effective lawyering and affordable lawyering was to effectively start a union for homeschoolers. And that's how HSLDA began, is with the concept of we were forming effectively a parents' union to stand together. And so we began, and it got going slowly, and it took about 3 years for the number of members to reach sufficient critical mass that I could even come to work for HSLDA in any kind of, I didn't get paid for the first 2 years. I was just a volunteer. It was still in the organizing stage. Fortunately, I worked for Tim and Bev LaHaye during that period of time, and Bev was the head of Concerned Women for America, and I was doing ADF kind of work through them. And it was, very friendly. They liked, I mean, their daughter was homeschooling. They liked the idea, so they were very supportive of me doing this on the side. But after about 3 years, it grew to both the financial size and the need side that I could come to work full time. Now, in the meantime, we had some first a part-time lawyer, Jordan Lawrence, and then a full-time first a law clerk, Chris Klicka, and then he became a lawyer eventually. And so Chris was there working at HSLDA, but then I was there full time myself. And so that took a while to get going. And so in the process of, thinking of starting something, there's going to be an on-ramp kind of an experience. It will take a little while to get it built up. But, if there's ways that you can do it incrementally, that's a good thing. But the first lesson is that if you're going to bring successful legal defense to homeschooling, we've got to organize homeschoolers and we've got to agree to stand together. That's the only way it works. And so the second thing, moving to litigation strategy, I don't know that I was aware of this in a kind of a conscious sense. I think I was subconsciously aware of what I'm about to share from the very beginning, from my very first cases, but it later became very clear to me as to what the deal is. In American constitutional law, the formal burdens of proof are on the government. When you make a constitutional claim, well, the person has a burden of showing a couple of things as a preliminary matter, but where the real clash is, the governments have the burden of proof of that their interest is compelling, as the way we talk about it, and that this is the least restrictive alternative, or it's narrowly tailored. Those are two ways of saying essentially the same concept. And the government's supposed to have the burden of proof on both of those things. So what I learned is, regardless of the formal burdens of proof that are supposed to be followed by judges, until the judge felt like the kids in front of them were okay academically, it didn't really matter what the formal burdens of proof were. And so I went into every case recognizing that the first thing I have to do is assure this judge that these kids are okay. And once the judge was certain that these kids were okay, then it became a lot easier. It didn't mean we're going to win per se, but without it, it did mean we were going to lose. And so the only open door for victory was to make sure that the judge felt that the kids were okay. And there were, two basic ways to accomplish that in a shorthand fashion. Either we had some kind of a standardized test administered that would show the judge that the kids were doing fine, even if the law didn't require it. We would have someone qualified to administer this test, no one from the public schools, but someone that we had, we either HSLDA or the family had retained to administer an appropriate standardized test, and through that method show that the kids were okay. The other way to do it in a quick fashion is to get a person with a proper educational background that couldn't be disputed by anybody reasonably. Someone who had been a teacher in the public schools, or an administrator in the public schools, or had a master's degree, or some set of credentials that would make their opinion readily credible. Review the family's situation independent of the government, and simply write a report that the kids were okay. Give an assessment of that the children were doing fine. And so when armed with that kind of information, it was critical to disarm the judges, because there's just no getting around the fact that you put a case of educational concern in front of any judge, frankly, probably any place in the world, their first question is going to be in their heart, are these kids okay? And you just have to deal with that right at the outset. The second thing, and this is to some degree the legislative side of things, but it spills off into litigation as well. But I'm going to approach the question from a legislative perspective, and that is, I found it to be incredibly important that every member of a legislature, or what's often called a parliamentarian, depending on your frame of government, that every parliamentarian actually knows a real homeschool family, preferably from their district, so that they're never voting about a homeschool matter in the abstract. I want them thinking about an actual couple, and the couple that made me aware of this principle. Their names are Joe and Zan Tyler, and they live in South Carolina. And the way I discovered it is I was in the South Carolina legislature working on something, and I was talking to a legislator about homeschoolers, and he said, "I don't think about homeschoolers. I think about Joe and Zan Tyler. And so when I'm voting either for or against Joe and Zan." And that just turned a light on for me that it's extremely important, and the a corollary to that is that if at all possible, homeschoolers need to be open about who they are and what they're doing. That to their neighbors, to everybody, because public opinion will ultimately change litigation. Public opinion will ultimately change legislation, both. I mean, our ADF's case, the Jack Phillips case, the Masterpiece Cake Shop, pretty well known worldwide. And we just absolutely were convinced, and it proved to be true, that we had to convince the public of this idea. Jack Phillips serves all people. He will not deny gay people services, but he does not deliver all messages. And that one sentence, there were national opinion polls, showed changed public opinion about these things by about 5 or 6 percentage points, moved in Jack's direction by that. And it carried the Supreme Court 7-2, where everybody thought we were going to lose 5-4. And so in the same way, when most Americans began to believe that they knew some homeschoolers and they thought they were good people, that spilled over into courtroom success, and that spilled over into legislative success as well. And so making sure that you're good neighbors, that that your legislator, your parliamentarian gets to know you, I think is a crucial strategy for the holistic role of the movement in that regard. The fourth point I want to talk about is the various components of the homeschooling movement. And Mike, the way you outlined this and the framing of GHEX, and I was at the first couple of GHEX meetings in Berlin, and there was another one, I don't remember where the other one was, but I was at the first couple. And the GHEX is aligned with the principles I'm going to say, and that is, it's a mistake for Christian homeschoolers to, in this context, in the context of standing up for each other's rights, Christian homeschoolers should not be standoffish to secular homeschoolers. We need to stand with each other. And so it's a mistake for Christians to say, no, we're only going to stay together, and we're only going to defend the right of Christian homeschoolers. It's also a mistake for secular homeschoolers to require Christians to leave their faith at the door when we're talking about these things. We need to let well, there's not just two sides, but there's a continuum of homeschooling beliefs. And so we need to let all of us let each other be each other. Let us be who we really are, and not say to anybody that the price of entry into the room is to leave who you really are at the door. It won't work. And so there has to be, this is often said in the free speech context. I may disagree with everything you say, but I'll defend to the death your right to say it. Well, the same principle is true here in homeschooling. I may have a different approach to home education. I may have a different philosophical reason for wanting to homeschool, but we just say none of that matters. We're going to defend to the nth degree each other's right to homeschool, and that camaraderie, that sense of unity on these questions is essential. Having said that, I do want to say a word to my fellow homeschoolers as my last point, and I'm going to be my fellow Christian homeschoolers in particular, and that is, don't neglect your duty to pray and the duty of faith in this arena. Faith and prayer are absolutely powerful, and I could tell enough stories to take up not only my allotted time, but all of you allotted times as to how God answered prayer in this arena. But I'm just going to tell one story. And it's, of course, my favorite. I would have chosen another one. This is my favorite story. I was defending a woman named Robin Deagle in Ohio a very long time ago now, probably in the 1990s. The way HSLDA was organized in those days, there were three lawyers, Mike Smith, Chris Kuka, and me. And Mike and Chris essentially did almost all of the office practice, dealing with school districts, dealing with truant officers, and I did a little bit of that, but not a lot, reduced load there. But I essentially did all the litigation, both the trial litigation and the appellate litigation in those days. And so Chris or Mike would work up a case, but when it actually got to court, I took over. And so I never had actually talked to this lady, Robin Deagle. I wrote the trial brief ahead of time, sent it to the court, and was on a plane to Ohio a couple of days before the trial, and I was going to spend the day before the trial with Robin to get her ready for trial at this. It was a very low level court, and so we were going to spend the day together, getting her ready for trial. So I got to her house. It was I need to say one more thing as a preliminary. I had because of what was in the file, I initially had written the brief I'd written, argued religious freedom and a pretty standard Christian set of beliefs about homeschooling from some notes that Chris had in the file. And so the brief had been written that way. But as I was reading over the file in more detail on the plane, I began to have real doubts about this lady's religious beliefs. I thought I may have overstated her beliefs. And so that was on my list of things to cover with her. So I got to her house. It was a beautiful June day in Ohio, just a gorgeous day. And we sat at her picnic table in her backyard and did this several hours of preparation. And went through a lot of material, went through her educational material. And it came to a point where I had to talk to her about her religious beliefs in order to set the stage for the religious freedom claims that we were making. And it became really apparent that she believed in God, but that was about it. She did, she had a high respect for the Bible. And so I shared the gospel with her. And she prayed to receive Christ right then and there. And I was really ecstatic. I thought this is so wonderful. And I told her that I thought God was going to do something special in her case to welcome her to the family of God. I'm Baptist by background, and we're not given to things like gifts of prophecy and stuff. That's, it's just, it's in that Baptist hymnal that we're not allowed to do things like that. And so Kristen Wagner, our general counsel at ADF, she's in the Assemblies of God. And that's more, kind of that realm. But anyhow, that's what I said. And I told her to start reading the Bible, and I got to the court the next day with her, and judge called the lawyers into chambers, and he said, "Mr. Farris, I've read your brief. It's a pretty good brief, but you're going to lose today." Now, I've been in a lot of courts where I thought the judge made up his mind before we ever started, but they're not supposed to say so. They're supposed to actually listen to the evidence, and so um, I, the Bible verse that immediately came to my mind at that point was from Deuteronomy, where it says, if the prophet says, thus saith the Lord, and it doesn't come to pass, you're supposed to take up stones and kill the false prophet. And I had just hoped that Robin didn't start reading in Deuteronomy, but stayed in the book of John, like I suggested to her. And so we started the trial. I couldn't tell her. I didn't have the courage to tell her. All I said was, this is going to be a tough case. That's what I said. And so the superintendent was put on the stand, and came time for me to cross-examine. And a question jumped into my head that I had not prepared for. I never asked it in any other case ever, before or after. And it just jumped in my head, and I asked it. I said, Mr. Superintendent, did you get any legal advice before you denied this family the right to homeschool? He said, well, I didn't talk to any lawyers or anything like that, but I talked to some government officials. I said, well, like who? He said, well, like the judge here, for one. I said, you talked to this judge about this case before it was ever filed in the court? He said, yeah. Well, we won that day. And what happened is the judge took the lawyers back in chamber and yelled at the prosecutor and said, you go tell that superintendent to approve this family's homeschooling right now. And that was the end of the case. And so I've seen God powerfully work in this area. So don't forget to pray.